What I'm going to say this evening comes with a caveat, well, two caveats really. First, I've deliberately chosen to talk about the law in relatively general terms rather than with great specificity, save where it's necessary for argument. I know that the glazed look that descends upon people who ask me what I do, I know from them that the words law and boredom are insufficiently antonymic for me to get away with a treatise on black letter law. So for the lawyers then, my apologies. I hope you'll forgive what might be regarded as generalisation in favour of accessibility. The second caveat is what I'm presenting is not a complete bit of research. It's something on which I've been pondering for a little while. It's a natural congener to my research on liability for statements and on deceit. And that's obvious enough as to how it relates. But the subject has recently reasserted itself at the centre of popular opinion and fears, thanks to proposals and inquiries led by various governments, and thanks also to the leader of the free world, the best leader of the free world. The French are proposing a law that will allow the government to shut down websites peddling fake news during elections. The UK government, under slightly more vague terms, which is either a good thing or a very bad thing, is proposing to resurrect a unit charged with combating fake news for reasons of national security. I say resurrect. You may recall, perhaps fewer of you than I had anticipated, may recall the Information Research Department that was set up to counter Soviet propaganda during the Cold War. I say ill-fated because it was closed, having garnered something of a reputation for peddling sort of counter-propaganda of its own. Anyway, my purpose then, and I hope this feeds into the cutting-edge ethos, is to add to a conversation that's happening across the world right now. Fake news, though, is nothing new. The phrase may be an inelegant neologism, and let's not forget that it was actually Clinton that coined it. But the practice is as old as deceit itself. What is new, and what makes this problem so dangerous now, is the extent to which this fake news can be propagated, disseminated, and entrenched. It's no great insight to suggest to you that social media allows for the creation of or dissemination of news at an astonishing rate. A small town in Macedonia is home to hundreds of websites dedicated to the dissemination of entirely fake news. The incentive, and there's a sort of numbing inevitability about this, is ad revenue paid for by Facebook. So this has been termed the hometown of the fake news gold rush. One fake news story in particular, alleging that Hillary Clinton was to be indicted for crimes related to the alleged email scandal, was shared 140,000 times. Not seen 140,000 times, but republished 140,000 times. Very few news stories get anything like that sort of coverage. And this was from a website dedicated to fake news. Its raison d'etre was fake news. Its sole product was fake news. And it was from a small town in Macedonia. What is more terrifying, though, than the propagation and dissemination is the ability of these stories to entrench themselves, in fact, amongst a sympathetically minded following. Professor Lewandowski of the University of Bristol, giving evidence in the Digital Culture, Media and Sports Select Committee last week, that needs a shorter title, said that one of the things we know with great certainty is that people's opinions are held to the extent a person thinks it is shared by others. There is empirical data to support this. So if you believe something that's absurd and you happen to live in a small town in the Middle Ages, you question your beliefs to an extent because you can at least appreciate that you are not aligned with everyone else. The problem with social media in this respect is that with billions of users using it, you are far more likely to find a community that shares your beliefs. It becomes, if you like, an epistemic community, if that isn't too strange a term. The evidence presented by Professor Lewandowski was concerning, though I think not at all surprising. To quote him again, in a recent Australian study on climate change, only 8% of people were found to completely negate the idea that the climate is changing. But those 8% thought that their opinion was shared by half the population. Half the population. And that was because they're all in an echo chamber and talked to each other and felt their opinions confirmed. End quote. So uninhibited social media, then, for all its benefits, is a petri dish for ignorance. We are, in part, to blame for that. The traditional repositories of reliable information, so journals and to a considerable extent, broadsheet newspapers, have become subjects of the fake news accusation. Their accusers range from executive branches of government to those people who peddle unthinking relativism and truths plural, yet who have no qualms about brandishing as fake anything with which they happen to disagree. This casual, self-serving use of the phrase fake news is serving to erode trust between press, between government, between universities, and the people we serve. And so we must act. But the question is, and it's a question I want to address now, is act against whom, or more specifically, what? What is the enemy? This is a slightly harder question to answer than it first appears. Laws, by and large, require a relatively specific notion of wrongdoing or infringement. At what point have I committed a crime? At what point have I breached my obligation to a patient, say, or to an employee? There are many examples where we can think of where it's relatively unequivocal. Under the law of property, if I own something, I have a right over that good, and that right trumps anyone else's claim thereto. And so we know that any usurpation of my right to that good by another without lawful excuse infringes my property right. The boundaries of that right are pretty unambiguous. I own my iPad. I don't own the lectern on which it is sitting. But similarly, you don't own my iPad simply because perhaps it might be sitting on your lectern, and so on. We can think of many other examples under the law of unjust enrichment. If I transfer my money to you by mistake, if there's no legal explanation for you having my money, you come under an obligation to return it. This is not complicated. If a surgeon operates on you against your express consent, then he's liable in damages for battery. If you're over the legal alcohol limit for driving and you drive, you are guilty. In each case, the right or the interest is knowable beforehand. It's knowable ex ante. Where the notion of wrongdoing is not apparent before the fact, we generally criticise that law. Subjecting people to laws that cannot be determined ex ante is a profound corruption of the rule of law. We must ensure that like cases are treated alike, that we do not regulate varyingly the same behaviour, that we do not at once say that it is wrong or not wrong, or that it violates two different wrongs without a clear understanding of why. The law must then, at a minimum, pay heed to taxonomy. Where are the categorical limits or legal boundaries? What is it that makes you guilty of one crime and not another? Now, there are lawyers who will disagree with me on that point, but I think here the taxonomy is relatively simple. They belong in the set marked wrong. Anyway, when we talk about fake news, then, the first question we must ask is, what is fake news? Now, when I ask this question, It's easy, and a lot of people have done, it's easy to point to these Macedonian farms of digital deceit and say that. Well, yes, I agree. But what aspect of their behaviour is wrong that we wish to prohibit? The problem with pointing to very obvious examples of wrongdoing is that it actually tells us nothing about the complicated, about the grey areas of wrongdoing. We see this fallacy all the time. Many of you will have seen on social media an analogy using tea to demonstrate consent to sexual activity. And my apologies to my second-year law students. I spoke about this only the other day, but here we are. It's being reiterated again. So the analogy runs thusly. Would you like a cup of tea? No. Well, here's some tea anyway. And this is used as an analogy as to consent in various sexual offences. And as an analogy, it works sensu stricto, but it doesn't reveal anything meaningful about the nature of consent. So, for example, let's stretch the analogy further. If I buy what you tell me is tea, and actually it turns out to be the leaves of the tum-tum tree, we would agree, and luckily so would the law, that my consent is defective. It is vitiated by this misinformation. So the contract that founded that exchange is not a pure contract. It doesn't work. However, if I were in a bar and I told a lady sitting beside me that I was an astronaut and she consented to ardent nighttime activities on the basis that she had always wanted to engage in such activities with an astronaut, would we say that her consent to that activity was vitiated by the fact that I am but a greasy lawyer? Would we call that rape? It's not so obvious that we would, or should. Obviously, I don't propose to answer that question now, but I mention it simply because it demonstrates very well the explanatory limitations of the obvious example. And so we must look away from the Macedonian deceit farms. So what then is fake news legally? There are a number of ways that we might define fake. We'll take the obvious interpretation first. So fake means inaccurate. If someone says Nick Hoggard is 6'7" tall, we would have little trouble describing this as fake. It's manifestly not true. It's wrong. What if somebody describes me as 5'10"? Now, this isn't true either. I'm 5'11" for, if you want that little nugget of personal information, I've given it away for free. But such a statement isn't so obviously misleading. It slightly depends on the purpose to which it's being put. But it doesn't paint a manifestly incorrect picture. Indeed, the picture it paints is broadly accurate, albeit that the specifics were wrong. What about those statements that are wrong relative only to some accepted, though perhaps unspecified, context? Nick Hoggard boasts a slim figure. This statement is clearly incorrect if, as we assume, the comparator is to humankind generally. But it's not so obviously incorrect relative to, say, an elephant, set against whom I'm barely even overweight. Inaccuracy, then, is no guarantee that a statement is misleading. By contrast, accuracy, in the narrow sense, is no guarantee of truth. It should, I hope, be clear that the misleading nature of a statement or article should not be sufficient to invite the interference of the law. Steven Pinker, the liberal psychology professor from Harvard, and my apologies to friends about whom to whom I've moaned about this for some time, but nonetheless, Steven Pinker accidentally became a hero of the alt-right earlier this month. It's fair to say that his views are really quite a long way from the alt-right. But anyway, in November he was speaking at a conference in which he argued that by refusing to allow discussion of statistics which are, in a narrow sense, true, the majority. So, for example, a couple of the examples he said was, it is a fact that the majority of suicide bombings are committed by Muslims. It is a fact that different racial groups commit crimes at different rates. Having said these, I now run the identical risk that he did. But anyway, we lose the ability to frame serious and valid counter-arguments about why these facts, taken alone, are misleading and clearly do not license racism, prejudice, etc. So his argument was that we have to be able to talk about these things rather than hide them. Take or leave the argument, but that's what it was. And worse, that when these facts are presented without the counter-argument, then there's no defence against the people who do take them to their repellent conclusions. There was an almost amusing irony then when this video was cropped, such that Pinker appeared to be rattling off a list of statistics proving, I use inverted commas there, innate differences between races, religions and sexes, etc. Not only did he become a hero of the alt-right, but he became the villain for hordes of lazy journalists. Ben Norton, for example, accused Pinker on Twitter of being the darling of the alt-right. And this was done pejoratively rather than as a description of the newfound status that Pinker had acquired amongst the alt-right. So as a representation of Pinker or his argument, this was clearly untrue. Indeed, it was precisely the opposite of his views. Any common sense understanding of the word fake would surely include this. But can we seriously prohibit people sharing news or views out of context? Steven Pinker himself may have an interest in his views not being misrepresented, although what can be done about that in law precisely is less easy to determine. But it's far less obvious that I have a legally relevant interest in his views being misrepresented by a party with whom I have no legal relationship. It may well be that those who shared the cropped video cared not at all for Steven Pinker's views qua Steven Pinker. Perhaps it was enough for them that the video contained arguments with which they agreed, albeit that the rest of the video did not. So the video is untrue relative to what was said, or relative to its context, but what was shared of that video is a true reflection of the beliefs of the person who shared it. I think most of us would, and I submit should, be uncomfortable about any law drafted so widely so as to prohibit news that is dependent on a specific interpretation of what is fake. Now, for the avoidance of doubt, I must make clear that I am not arguing that there are no truths, or that everything can be simultaneously true and false. I neither believe it nor am particularly qualified on an epistemic level, so I'm not arguing anything of the sort. So if somebody said that I was in the pub earlier, rather than lecturing my second-year undergraduates, that would be demonstrably untrue, unfortunately, albeit that it might be an entirely believable story and of no surprise to anyone, but it is clearly untrue, and that fits into our simple interpretation of fake. So I'm not saying that the simple interpretation of fake is wrong. What I'm saying is it's not really the whole story. What I'm trying to make clear then is that a law seeking to ban fake news must, ab initio, have a clear view or clear notion of what the term means, what types of statement are inaccurate or misleading, and what of those statements will be caught in the net. Claire Wardle at the Shorenstein Centre in Harvard is doing excellent work on this. In defining categories of fake news, more than I have time to go into here. But work like this must be a precursor to any meaningful consideration of a public law response. So that is the first problem with legal responses to fake news, that we don't know what it is exactly we're fighting. So we may, in the alternative, wish to say that the intention of the creator or the propagator, or the disseminator, matters. It may be misleading in various ways, but perhaps we only care about wrongdoing as some kind of moral notion. This is not so much about the accuracy per se, it is about a moral notion of wrongdoing. So in criminal law terms, this would be the guilty mind or the mens rea. So we turn the attention, in a sense, to the creator rather than specifically or solely on the news itself. This has some intuitive appeal. Those Macedonians, for example, peddling fake news, were doing it for malicious reasons, perhaps, as perhaps might the Russians during their alleged involvement in the US elections. So we could, on this basis, somehow save the alt-right by saying, well, no, your views, or at least sharing them, was not malicious. The cropping of the video, misleading in one sense though it was not malicious. They're simply peddling abhorrent but genuine views, and thus is not to be caught in the net. Maybe. I'm not convinced by this either, because we soon run into a similar problem. That is, what counts as malicious? Dishonesty, perhaps? Well, the criminal law students here will know that the law is very bad at defining dishonesty. The best and current definition that we have, actually I will rephrase that, the current definition that we have, it's best on a very strict legal sense in that it is the current law. The current definition we have for dishonesty, and this comes from the Supreme Court late last year, late 2017, in a case called Ivy and Genting Casinos, is that dishonesty is what a jury determines the reasonable person would regard as dishonest. This doesn't really sound like a law knowable before the fact. In fact, theft is a really problematic area in the law generally. Theft law, now the act of stealing, doesn't involve anything that's obviously morally wrong. The act requires an assumption of responsibility, an assumption of the rights of the owner. But this doesn't necessarily mean that you are doing anything wrong. There could be many legitimate reasons why you have assumed the rights of the owner, including, in some very weird cases, by virtue of being the owner at civil law. They were nonetheless found guilty of theft. What turns, in that case, an honest, or, well, no, that's an awkward term in this context. What turns a wrong act or a correct act into a crime is the fact that a jury, after the event, say that an ordinary, reasonable person would have regarded it as dishonest. Now, we're lucky in this country in that despite the fact that that is a truly terrible law that has been interpreted very badly by the courts, the Crown Prosecution Service are not so foolish as to be prosecuting every act that assumes the rights of the owner and putting it to the test of dishonesty. No, there is obviously some sense in which they only bother prosecuting those things that the police have been called to. And so there is a sort of inbuilt safety mechanism. But as a matter of doctrinal law, it's very bad indeed. And so in theft law, dishonesty bears an enormous weight. Have we defined it? Not at all. So dishonesty, I think, is not a very sensible path to go down, given that it has failed so magnificently in other areas of law. We need to beware, then, those instances where if the essence of the crime, or whatever you want to call it, is to be determined after the fact, by what, and this is, in the context of fake news, by what a government or quasi-independent body would regard as dishonest or malicious, I think at that point we're in very dangerous territory. Free speech would struggle to survive such a violation. And if you think this sounds like hyperbole, how many mainstream news services might have been shut down if a law as broad as this existed elsewhere in the Western world. You can, of course, define maliciousness or dishonesty more specifically, but would it be a better definition? Perhaps we might want to define maliciousness as self-serving. But isn't presentation of my own views self-serving to an extent? We tend to regard all too easily those who present opposing views, so climate change deniers, say, as self-serving, fat cat or oil baron or lazy car driver. Rather, they are self-serving views rather than possessed of our noble intent. Worse, the decisions need to be made very fast. We are very bad at negating views that have already been formed. As Professor Bakir from Bangor University noted, we are story-driven people. If you present a narrative, even a fake narrative, it's very easy to remember. Negation of that narrative, absent of further narrative supporting the negation, does not resonate in the same way. And so the strategy that is being, or one of the possible strategies that is being investigated at the moment, is the ability, in a sense, for governments to get ahead of fake news, to set the agenda, to set the story. News already comes out pretty quickly. I can't quite conceive of how that would work. But nonetheless, that is one possible way of dealing with our own psychological shortcomings. I'm no psychologist. I make no comment on that particularly. But either way, whichever way you look at it, this is not an arena that's amenable to careful judicial scrutiny. This is not an arena where juries will have time to think about what the intention of website owners might have been. The intentionality element, then, requires work. It's clearly important if your objective is to ban fake news through the law. I think you do need to consider the mental element of wrongdoing. But it really needs work, and we're not there yet. It might be possible to draft a law that's knowable ex ante, whilst also respecting fundamental free speech. But my word, is it difficult. So I'm sceptical of a public law response to this problem. Unfortunately, private law doesn't really come to our aid either. I should explain that the law sits with varying degrees of comfort in two camps. So you have private law and you have public law. Private law concerns those rights that we have that are somehow exercisable against or realisable against other people. So, for example, think of a contract law. I want to buy a newspaper. I say, can I buy a newspaper? He says, yes, that will be £2.50. And we do the exchange. That's a contract. If he fails to perform, I have a right. This is standard private law stuff. And in the same way that negligence is private law. If somebody crashes into me and I'm injured, I have a claim against them specifically. It's against a person. More relevantly for fake news, perhaps, albeit still not helpfully, defamation, where somebody has said something, has said a defamatory statement, i.e. it's a statement that lowers reasonable people's estimation of you. Your reputation has been lowered in the estimation of right-thinking members of the public, so the test is. Then you will have a claim against them, and it will be a defence for them that the statement was true, and if it's not true, then your claim succeeds. But obviously that requires something specifically said about you, such that it is your reputation that is on the line. That says absolutely nothing about misinformation in general. And so we might then ask, well, do we have a right more broadly to information? I mean, it's an observation at once fundamental and trifling that we rely daily on information we're often unable to question, information provided not necessarily directly, but to the public at large. So this information, as we know, takes manifold forms. Weather forecasts, for example, directions, road signs, allergy advice. Statements such as these dominate our lives. But much of this information is provided without any obligation on the part of the provider, inasmuch as he or she is under absolutely no obligation to the receiver, to any one of us, to provide that information. Now, okay, with allergy advice, there may be specific regulatory requirements, but the obligation is flowing upwards to a regulator. It's not flowing sort of horizontally, if you like. So if I approach you, let's take a really trite example to demonstrate the problem with conceptualizing rights to information. So if I approach you in the street and ask you for directions to the nearest purveyor of groceries, then no matter how lost I am and no matter the extent of my burning need for asparagus, you infringe no right of mine nor curb any obligation of yours in failing to provide that information. That I rely on you does not, ipso facto, generate any obligation on your part, nor right on mine. But we could say, okay, well, there's no obligation to provide information ab initio, but what if, having provided it, having decided you're going to provide information, is there some obligation or right? And I don't want to get onto the difference between obligation and right, but I think on basic terms we understand it. Is there something we could say about your obligation to provide accurate information? Well, I don't think that if you choose to provide it, I find any further entitlement to accurate information. And certainly not simply because I'm in no position to question it. I mean, short of hearing your advice and cross-checking it with some hapless stranger, an exercise as potentially futile as it is mildly bizarre, I genuinely rely on the accuracy of the information because I know no better. The same is true of the weather forecast. My own inability to foretell the weather is limited by a distinct paucity of data on my part. I'm in no position to question the advice of the weather forecaster, short of simply saying, well, other weather forecasts are different. This may all sound like very sort of bizarre examples, but actually what it tells us is quite a lot about how we regard our right to receive information. So the temptation is to say that my genuine reliance on you should generate an obligation on your part. And this is the counterpoint to an alternative formulation, which is that if I were able to check with relative ease the information provided to me, so let's say if I asked for the directions, but I also have access to a map on my mobile phone, then it would seem strange to burden the generous passerby with any form of liability in relation to the advice. It would seem strange to burden them with legal obligation. However, it doesn't follow, certainly as a matter of logical necessity, that my inability to check the information should therefore generate an obligation on your part. The existence of thing A may provide a good reason for not doing action B, but the absence of A does not necessarily provide a reason for definitely doing B. Okay, so example, Nick. Right, well, were it the month of June, I may note that it would be a very bad time to eat oysters. Another bit of free advice for you. And so choose not to. However, were it not June or May, July, August, I do not then become subject to an imperative to eat oysters at every other time of the year. A reason then may be sufficient on its own to mandate or prohibit action. But merely being sufficient reason does not allow us to suppose that it's the only reason, or even a necessary reason. So the crude examples that I've just given are a couple of the manifold instances where liability to provide accurate information is clearly not generated, despite the fact that I rely on the information. Indeed, there's a non-trivial, though I think still troubling argument to be made that my reliance on you is a very good reason not to burden you with legal liability. The law should encourage you to do me a voluntary favour and not saddle you with the consequences of failing to do so, or failing to do so well, which is the same thing. On its own, however, the reason is clearly insufficient to negative a finding of liability. The non-negligent action may carry with it some benefit, but that it carries with it some benefit is no reason to ignore the effects of negligent action. Surgery to correct chronic back pain is clearly of benefit, but it's less so if the result of the negligent surgery was death. It would be no defence for the negligent surgeon to argue that there was benefit in posse, such that his or her negligence should be ignored. And actually, surgery is an interesting way to finish this point about rights to information, because often people say, right, you tell me there's no right to information, but if I am lying on the surgery, in the operating theatre on the table, or just beforehand, the doctor has an obligation to provide me with information. I have to be able to have informed consent about what happens to my body when I'm on the operating table. Surely there, if in any arena we can find a right to information. Sadly, not so. The doctor does not have to tell you every conceivable risk that exists. The doctor is under an obligation to act in your best interests and enable you to make some form of informed choice about what to do with your body. But there is no obligation on their part to tell you every risk, nor indeed a right on behalf of the patient. The reason, on one practical level, is that if the doctor gave you a long list of every possible thing that might conceivably happen in the surgery, a lot of people would just go, no, even if the chance is really remote. So there is some sense that they have to act in your best interests. Your consent as to what to do with your body is paramount, but that does not translate synonymously to a right to information. So within private law, we struggle to find a right to accurate information. Now, to non-lawyers, this may have appeared somewhat obvious, in the sense, to lawyers this may have appeared obvious. Well, of course, we were never really going to find the answer to fake news in the private law. But I think it really is worth fleshing out why that's the case, and therefore why the burden does have to fall on the public law, if the law is the appropriate response at all. And I don't think enough work has been done on establishing exactly why the private law would fail. Most people dismiss defamation correctly out of hand, but then don't really consider why it is that we can't use the private law. And you never know, it may be that I'm completely wrong and that there is a right to information to be found, a right to accurate information. And if I'm wrong on that, then maybe the private law could become some forum of redress, although you then end up with a further problem in that who would become a journalist if you could be sued by anyone who happened to read your article. This is a policy argument commonly termed the floodgates argument, which I have mixed feelings about. The floodgates argument, the idea that the greater the systemic harm you might cause, the less likely you are to be found liable. That seems like a weird formulation. Your negligence has produced devastating effects, and because so many people could sue you, we're not going to allow anyone to sue you. That seems odd, but nonetheless, that is what the law is, and I can, to a point, understand it. So, as I've said, I have some reservations about the public law. I think defining exactly what fake news is in a way that is tight enough in order to cover that which we want it to cover and not so broad that we end up severely curtailing free speech. I think that project is difficult. I'm not convinced it's possible. I'm similarly very sceptical of the endeavour somehow to talk about malicious spreading of fake news beyond the obvious example where it feels intuitively to be malicious. Actually defining what we mean by that in law is very difficult. And again, I asked in the abstract to this, we prohibit these at law at what cost? And this is a political view perhaps rather than a legal one, but at great cost if fundamentally you are aiming to protect free speech and democracy. And of course, that is our initial objection to fake news, is that it corrupts both of those. So if you make the situation worse, you're essentially just shifting the culprit from a peddler of fake news to a government whom we would struggle to hold to account through a well-drafted law. Then there is a sort of there's an internal contradiction or a hypocrisy there. Now, I don't want to end quite so negatively, and you'll be grateful that I am coming to the end, in that, well, okay, firstly, clearly, there is merit in prohibiting the most egregious examples of fake news. And clearly we must be very careful in how we do that. But I think a more immediate and much more effective response is to look rather closer to home than to appeal to the law. One of the easiest ways of combating deceit is, and this sounds trite, but it's true, is not to believe it. It is, in a sense, to read widely. It is to cross-check information. It is to trust, actually, our repositories of reliable information. I mentioned right at the beginning that one of the problems we have is that we bandy around the term fake news. We create disrepute amongst those institutions that are professional, that are not perfect, but are professional, and are a world away from the many websites in Russia and Macedonia that solely peddle fake news. So I think we've got to be very careful about how we erode trust, that we aren't comparing apples and oranges, or whatever the idiom is. So that is a more immediate and a more effective way of dealing with the problem. And the more we look to law, rather than looking at ourselves, I think the more trouble we get into. We have to fight our way out of this problem. But the law is not going to do it for us, I hope. Thank you.